disciplinary case, passing of final orders. After getting the inquiry officer's report, the disciplinary authority has to study in depth all records relating to the case, such as charge memo, served copy of charge memo and explanation of the accused, the questionnaire form, inquiry officer's appointment orders, records or evidence which form basis for the charges, the inquiry proceedings, depositions of witnesses of prosecution defense side, final statement of defense by the accused, inquiry officer's findings. The disciplinary authority has to give a personal hearing to the accused if it was not given earlier at any stage. The personal hearing given to the accused should be considered before passing final orders. The disciplinary authority has to verify whether the following procedures were followed. The charge memo contains a brief explanation or history of the case, no repetition of charges. Each charge must have been based on evidences and the name of evidence must be noted below each charge. The accused must have been called on to submit his defense. A mention must have been made in the charge memo that failure to submit explanation by the accused will be taken against him as on the merit of the case. Along with the charge memo, a questionnaire form must have been enclosed. Along with the charge memo, copies of depositions made against the accused during the preliminary investigation, which form basis for the charges, must have been enclosed in the charge memo. In the charge memo, it must have been mentioned whether the accused wants oral inquiry or personal hearing, or he required both. The accused must have been asked to acknowledge the receipt of the charge memo. The accused must have been asked to resubmit the served copy of charge memo duly signed with date. Accused must have been asked to resubmit the questionnaire form duly filled in. The questionnaire form along with his explanation. While issuing charge memo, the questionnaire form must have been filled in with the details of persons to be inquired during the oral inquiry, and the questionnaire form must have been filled in with the names of persons who were already inquired during the preliminary investigation in the presence of the accused. The disciplinary authority has to verify whether the accused was given enough opportunity to defend his case during the oral inquiry and a certificate has been given by him in the inquiry proceedings, and whether a final statement or defense given by the accused has been enclosed with the above report, and whether the accused was satisfied with the inquiry proceedings and the certificate obtained from him was enclosed with the report, and whether the signatures of all those present during the oral inquiry were obtained in the proceedings, and whether the inquiry officer has attested them, and whether the inquiry officer has affixed his signature in each page of the inquiry report, and whether the provisions of the Evidence Act were fully followed during the oral inquiry, and whether the inquiry by the prosecution defense side witnesses during direct and cross examination was in accordance with the Evidence Act, and whether the basis reported by the inquiry officer for proving the charges and for not proving the charges were satisfiable and correct, and if the disciplinary authority was not agreeable with the findings of the inquiry officer, it should be noted clearly as to how, and the disciplinary authority has to prepare a statement representing all these above points, and he must examine the above and come to a conclusion whether he could accept the findings of the inquiry officer, and if he differs with the inquiry officer's findings on any charge, he must make a record of it and as to why with reasons. The disciplinary authority then has to decide whether what were the charges found proved and what punishment would suffice for the proved charges, and he has got powers to award such punishments, and if not, he should recommend the case to the appropriate punishing authority for issue of punishment orders. And if he has got powers for the award of punishments, he decided he should issue a self-speaking final orders, and the punishment orders should contain an appeal clause with directions to the accused to make signature with the date in the served copy and resubmit it, and appropriate entries have to be made in the service roll or history of the accused, the details of the punishments awarded.